Falconer of Thoroton.
My Lords, I wish to ask the private notice question in my name, of which I have given advance notice.
Lord Keane of Ely.
My Lords, the Government has not proposed any breach of UK law. On occasion, tensions can arise between our domestic obligations and our international commitments, and we will always seek to resolve these as we have in the past. The freedoms and protections that we all enjoy rely on the rule of law. It is an important constitutional principle, and as a responsible government, we remain committed to it.
Grateful to the noble Advocate General for that answer. Brandon Lewis's acceptance that this government is deliberately breaking international law will be thrown in the UK's face for years. Expect dictators to justify murderous breaches of international law by relying on the Lewis mantra, specific and limited. We expect everyone to obey the law, the Prime Minister said yesterday, demanding compliance for anti-COVID measures. The Home Secretary condemned Extinction Rebellion for law breaking. The rule of law is not pick and mix with acceptable laws chosen by the Home Secretary or an advisor in number 10. This stinking hypocrisy chokes our country's reputation and destroys our government's ability to lead at home and make agreements abroad. In June 2018, the noble and learned minister, a law officer who I am surprised to see in his place, lectured on the importance of law, describing the law officers as champions of the law within government, and said their, quote, duty is to ensure the government acts lawfully at all times. Jonathan Jones agreed and left. Law officers and the Lord Chancellor must stand by their self-proclaimed duty or leave. Otherwise they will be dismissed as long on self-importance and short on the backbone their great offices require. Two questions. First, how is the admitted breach of international law consistent with the UK's commitment to the rule of law? Second, on what basis does he, as a law officer, remain part of the government?
Lord Keane.
My Lord, I think the noble Lord broke up slightly when he was asking his second question, but I certainly understood the drift of his remarks.
Second, on what basis does he, as a law officer, remain part of the government?
Thank you. My Lords, from time to time, as I indicated, tensions do occur between our domestic legal obligations and our position with regard to international law. And indeed, in 1998, the then Labour government passed the Human Rights Act, including Section 19, that required statements of compatibility to be made when ministers introduced legislation. Interestingly enough, Section 19(1)(b) had an alternative statement which required the minister to say that he was unable to make a statement of compatibility with our international obligations, but the government nevertheless wished the House to proceed with the bill. And in 2002, the Labour government introduced the Communications Bill with just such a certificate, because it was perceived that clause 309 of that bill could be considered to violate our international obligations under Article 10 of the Convention. So from time to time, we do face these tensions. And of course here, there is a very real tension between the direct effect of EU law pursuant to Article 4 and what would occur if we had no agreement at the end of the transition period, and if there was no determination by the Joint Committee as to the way forward under the Northern Ireland Protocol. And that is because there are other provisions apart from Article 4. There is paragraph 4 of the protocol itself, which determines that Northern Ireland is part of the UK's customs area. There is Article 16 that deals with societal and economic pressures that could lead to us being in breach of the Belfast Agreement. All of these have to be considered. And against that contingency, ministers considered it appropriate to provide or ask Parliament to provide a means of addressing these issues. And at the end of the day, it will be for Parliament, the sovereign Parliament, to determine whether or not ministers should be able to deal with such contingency. And indeed, it will be for this House to determine whether or not they consider it appropriate for ministers to be able to deal with such a contingency. So in these circumstances, I continue in post, I continue to advise, and I continue to encourage and indeed stipulate adherence to the rule of law, understanding that from time to time, very real tensions can emerge between our position in domestic law and our position in international law. And it is not unprecedented for legislation passed by this Parliament to actually cut across obligations that have been taken at the level of international law. And in those circumstances, domestic legislation does prevail.
My Lords, may I remind the House that this is not a debate, we're asking questions. So if the next contributors could keep their questions short and ministers could keep their answers short as well, it would be to the benefit of everybody. Lord Thomas of Gresford.
Has such a certificate been given, as the noble and learned Lord referred to a moment ago in relation to this bill, suggesting that it does not comply with international obligations? The Prime Minister persuaded the Queen to prorogue Parliament unlawfully a year ago. His chief advisor, Cummings, unlawfully broke the law in his Barnard Castle jaunt. And now the Prime Minister will be asking the Queen to give her royal assent to what is effectively an unlawful bill, which quite deliberately breaks international law. The Tory Shadow Counsel General in Wales, the highly respected David Melding, resigned today, the head of the government's legal service 2 days ago. And having regard to the oaths of office to uphold the rule of law, why are the Lord Chancellor and the Attorney General still in office, even if the noble and learned Lord himself clings to it?
My Lords, first of all, the Minister presenting this bill has given a certificate of compatibility pursuant to the Human Rights Act. That has been done. Regards the further issues that are raised, it will be for Parliament to determine whether or not at the end of the day, it decides to pass this legislation. That is a matter for Parliament. And the ministers have presented the bill to Parliament for those purposes.
Please, Lord Judge.
My Lords, when by the Executive's own assertion it proposes to break the law in a specific and limited way, is it now to be exempted from the basic principle that the rule of law, which includes adherence to international treaty obligations, binds all of us? And if so, where will this violation of constitutional principle end?
As I previously indicated, my Lords, there are exceptional circumstances that arise from time to time where we find ourselves with a tension between our domestic legal regime and our obligations at the level of international law. There are also occasions when we find some conflict between different international law obligations. We adhere to the rule of law, but we understand the need to try and resolve the tensions that may emerge if at the end of the day, we do not have a post-transition agreement and do not have determinations from the Joint Committee.
Out of limb.
My Lords, does my noble and learned friend simply not understand the damage done to our reputation for probity and respect for the rule of law by those 5 words uttered by his ministerial colleague in another place on Tuesday, words which I never thought I would hear uttered by a British minister, far less a Conservative minister? How can we reproach Russia or China or Iran when their conduct falls below internationally accepted standards, when we are showing such scant regard for our treaty obligations?
My Lords, we're not showing scant regard for our treaty obligations. We're endeavouring to allow for a contingency that may arise very soon, which will require us to ensure that we can discharge our obligations to Northern Ireland. And that does create difficulties so far as the direct effect of EU law is concerned if there is no post-transition agreement and no determinations by the Joint Committee.
My Lords, as a non-lawyer, I'd like to ask a very simple question. Alongside the breach of our international obligations, is this not a breach of the respect for Parliament and for democracy, given that the Prime Minister signed up to this agreement, forced it through as part of the Act, and knows perfectly well that it's nothing to do with the negotiations towards the end of this year, but an admission of complete failure to understand what he was putting through Parliament?
I do not accept that. This is not a case of the executive or of ministers seeking to act contrary to the will of Parliament. This is a case in which ministers have brought legislation and laid it before Parliament for Parliament to determine whether or not provision should be made for the contingencies that I've referred to. This shows complete respect for Parliament, and if at the end of the day Parliament, and indeed this House, does not wish to confer the ability to deal with these contingencies on ministers, then they will not do so. It is a matter for Parliament.
Henley upon Thames.
My Lords, the government's used terms like clarification and safety net in describing this bill. It's nothing of the sort. It's a direct abrogation of the withdrawal agreement. And this is an issue about national integrity and the rule of law, as Sir Jonathan Jones recognised in resigning as Treasury Solicitor. May I ask the noble and learned Lord how he would describe a barrister with whom he had negotiated a detailed written settlement agreement, who then explicitly reneged on that agreement by announcing an intention to act in direct contravention of both the agreement and the law?
Clearly, the situation outlined by the noble lord does not reflect the situation that exists in the context of a potential tension between our domestic legal obligations to Northern Ireland and the terms of the withdrawal agreement in the event that we don't achieve the goals that all parties intended, including the ability to ensure the maintenance of the Belfast Agreement.
My Lords, tanks on the lawn will not, in the UK at least, herald the end of democracy or of adherence to the rule of law. It is shocking that the clause, and I quote, certain provisions would take effect, notwithstanding inconsistency or incompatibility with international or other domestic law, is set out in government proposed legislation. My Lords, will the government now either withdraw this derogation or provide a compelling justification for its inclusion?
My Lords, the government will seek to provide a compelling justification for its inclusion, and at the end of the day, it will be for this Parliament to determine whether or not that case has been made out.
Hunt of Will.
Declaring my interests as set out in the Register and as Chair of the Society of Conservative Lawyers, may I ask my noble and learned friend, the Minister, are we rewriting or amending the withdrawal agreement or the Northern Ireland Protocol?
My Lords, absolutely not. It would not be possible for us to unilaterally rewrite either the withdrawal agreement or the terms of the protocol. We quite understand that. And that is why my right honourable friend, the Secretary of State for Northern Ireland, was so candid in his remarks in the other place.
At the beginning of July, the government allocated £25 million to help businesses in Northern Ireland manage the regulatory and customs consequences arising from the Northern Ireland Protocol. By the 29th of August, this sum had risen to a staggering £355 million. Can my noble and learned friend explain how a unionist government is allocating hundreds of millions of pounds to police a border within the United Kingdom, which it claims legally does not exist?
I am not familiar with the precise sums that have been expended as explained by the Noble Lord, but I will say this. In terms of paragraph 4 of the Northern Ireland Protocol, it is expressly agreed by everyone that Northern Ireland will remain a part of the United Kingdom customs area. And we as a government are determined to ensure that that remains the case after the end of the transition period.
Ms. Crawley.
My Lords, government spokesmen have said all this week that we need to disapply aspects of the withdrawal agreement that we signed in case of a no deal. However, does the Noble Lord the Minister agree with his Irish counterpart, Simon Coveney, in his address to the Dáil last night, that the Irish protocol, agreed as part of the withdrawal agreement, is designed and empowered to operate in all circumstances, including the absence of an agreement on the future relationship between the EU and the UK? If the Minister agrees, then why is the government risking its international reputation by setting aside the upholding of international law?
Well, Lords, that is because we will require not only to consider the absence of a post-transition agreement, but also the absence of clear determinations by the Joint Committee, which would render the Northern Ireland Protocol potentially unworkable.